Good afternoon, ladies and gentlemen. Welcome to our live podcast. This is Dr. Olu Asekun here. This is another beautiful Wednesday. Thank you for joining. Thank you for tuning in. Today, thank you. As usual, we'll be discussing the few updates and then go into questions because we have very limited time today. We are going to stick to the 1 hour, so that's why we try to start on time. I just came in from an immigration office right now, so we're starting right away. Okay. So, because of the trouble in Middle East, not many news relating to immigration happened between last Wednesday and today, because the attention was focused on the Middle East. In fact, it was in the news on CNN. Of course, I've not had it from any official source, but on the news. Usually, I don't rely on news because sometimes it may not be accurate. So that's why I really don't like to rely on the news. I rather rely on official information, official source. So, but this time from the news, we heard that the DHS actually is diverting some of the resources that they are using on immigration. They are diverting it to preventing terrorist attack. That was in the news on Sunday, probably because of the American government involvement in Iraq at the time. But hopefully now that there seems to be a ceasefire, hopefully there will be less concern. But what we had in the news on Sunday was that they were diverting the resources that were meant for immigration enforcement to ensure the prevention of terrorist attack in the United States. So I don't know whether that's a good or bad thing, but I'm just giving you the news as we have had it. Now, recently, I can't remember precisely when, I did talk about when there was suspension of F visa, M visa, and J visa. That was a F visa is student visa. M visa is a vocational, still student, but non-academic. F is academic student. M is vocational student, non-academic. And of course, J visa. So those three visas were suspended. So applicants were not able to get appointment at the embassy. Those who already scheduled appointment were paused. But now, the Department of State has resumed processing of F visa, M visa, and J visa. However, they came up with a new requirement, and this is the warning I want to give to my listeners. Right now, they have enhanced the access to social media, especially in this day of the problem in the Middle East. Please, if you are not directly involved, don't get involved in this Middle East thing, because it will definitely impact the ability to get a visa to come to the US. In fact, to be precise, the Department of State released this information that there will be tougher social media vetting. There will be tougher social media rules. That is, they released new vetting guidelines to consular officers. They also said that applicants will have to make their social media accounts available for review. So what that means is that if you are applying for student visa, either F1 or M, which is non-academic, or J visa, if you are applying for any of them, you will have to provide your own social media account. So the information from the Department of State indicate that applicants will have to make their social media account available for review. So it's either you want to come to the US or you don't want to come. If you want to come, you have to provide your social media information. I don't know a whole lot about social media, but I believe they are talking about the social media handle. Is that the login information? The handle.
The handle is the username.
Yeah, that's the. So they are saying applicant will have to provide their social media account and make it available for review by consular officers. I know this is going to trigger a lot of privacy concern, but the problem is for non-citizens, for foreigners, it's going to be difficult to claim to actually apply for any relief under the U.S. privacy law. It is only people who are already in the U.S. who may be able to claim some form of privacy. But if you are still in your home country, I believe it's going to be difficult to successfully challenge that privacy aspect of that law, because this is going to be a serious violation of privacy, because whatever has been posted or is currently posted, even if you have deleted it, I'm sure that they have a way of retrieving some of this information. So the point we are making here is that if you are planning to apply for student visa, either academic, which is F, or non-academic, which is M, or J visa, now you have to be prepared under the new guideline to provide your social media account to consular officers for review. It is ridiculous, but it is what it is. I'm just reporting what the Department of State told us. Also, there is also a new policy change regarding asylum, especially as it comes to beneficiary, as it comes to derivative, that is family members, spouses, those who have either been granted asylum or have a pending asylum, and they want their spouses, their husband or their wife, to benefit from the asylum. So now, USCIS, the new policy is saying that for a marriage to be valid under the new policy for the purpose of asylum and for the purpose of derivative, the marriage must be valid in the country in which it was, in the jurisdiction where the marriage took place. Now, the significance of this is that we all know that there are some countries that have different laws when it comes to marriage. And a lot of people who are running away from persecution, they may not have the opportunity to properly conduct their marriages. But again, USCIS is saying that if the marriage is not valid in the jurisdiction where that marriage was conducted or contracted, then it means that the marriage cannot be used for the purpose of asylum, for the derivatives. So that is another change between last week and now. And of course, I believe that it was already in the news that the U.S. Supreme Court on Monday gave green light to the Trump administration that they can actually go ahead and deport people to a third country. Honestly, this is one of the saddest legal decisions that I personally, in my 32 years of legal practice, this is one of the saddest decisions that I've seen. We all know that the U.S. Congress, they have abdicated their role as a check and balance to the executive government. For some reason, President Trump has been able to kind of silence everybody in the Congress. So the Congress is not able to use their power as it was designed by the founders of this country. So our last hope has always been the judiciary. So for the US Supreme Court to rule that Trump administration can deport people to a third country, that is more than ridiculous. That is unimaginable. So what that means is that the administration has vowed to deport some people to Sudan. To the best of my knowledge, I don't know a lot about Sudan, but I don't believe that Sudan is an English-speaking country. I believe that Sudan is probably speak Arabic. I don't think it's an English-speaking country. So how do you deport somebody who is not a Sudanese, who does not speak Arabic? How do you deport such a person to Sudan? I mean, how can that be legal? How can? There's a reason there is sovereignty in every country. So how do you now deport people who are not citizens of a particular country to those countries, especially countries where they cannot speak their language? That is ridiculous. But guess what? The Supreme Court gave the Trump administration the go-ahead that they can do that. Although they have not ruled on the merit of the case, but the injunction from the district court, the Trump administration filed an appeal to challenge the injunction that was granted by the district court, and the US Supreme Court vacated that injunction, which means that the Trump administration, even without waiting for the merit of the case, they can continue to deport people to third countries. Countries that people have never been to, countries that people are not citizens of, countries that people may not be able to speak their language. This is what the United States of America has turned into. And I really pray that somebody someday will rise up to their challenge. They will rise up to their duties and responsibilities under the law, because this is ridiculous. There is a reason why there is separation of power. There is a reason why the founding fathers of this country, why they created a system of checks and balances. But the current administration is eroding every check and balance. Of course, we all know that the president has a desire to rule this country as a king. Unfortunately, the Constitution does not recognize a king. But from the action of the judiciary and the legislature, well, I take that back. From the action of the Supreme Court, I'm not going to say the judiciary, because there are district court judges, there are court of appeals who are standing up to the administration. But for some reason, the Supreme Court is complicit in some of these decisions. I don't even know how somebody can justify that. I don't know how it can be justified that somebody can be deported from the US to a different country where they have nothing to do with. I don't see how that is legal, moral, or even reasonable. It is beyond me. But this is what we have come to. Now, let's go into the questions. I believe that, can you please start posting the questions? Okay. Thank you, doctor, for all you do. Thank you, too. Good afternoon, sir. Can I divorce my husband while my VAWA is still pending? Oh, yes. VAWA and divorce has nothing to do with each other. Yes, you can divorce. Of course, even the government or USCIS or DHS, as the case may be, they don't expect you to stay with somebody who is abusive. Yes, if you have filed your VAWA, you can divorce. Yes, it doesn't have any impact on your VAWA because they don't expect you to live with somebody who is abusive. Next question, please. Okay. What is the best advice you can give to a person who wants to travel to Dallas from Delaware? Undocumented immigrant. Well, to be honest with you, except it is absolutely necessary, I will not advise a travel right now because number one, we all know that they have started enforcing the Real ID Act. And even if you travel by road, sometimes you encounter the police along the way. I mean, I have driven from Colorado before to Dallas, and that is not, I didn't go through any border town yet. I saw policemen along the way that asked for ID, driver license, and all of that. So so if I had been undocumented, it may have created a problem. The truth of the matter is that between Delaware and Dallas, to the best of my knowledge, air travel is safest. But the question is, do you have a real ID to travel? If you have a real ID, maybe a driver license, a state ID, or even a valid international passport, yes, you'll be able to travel. But if you have to travel by road, it is dangerous. If you don't have real ID, it is also dangerous. Like I said, if it is not absolutely necessary, if you are undocumented, I will not travel. Next question, please. Okay, is this same person? Because I see also starting the question.
Yes, this is a continuation.
Okay.
The first one.
Good afternoon. Okay, let me start from the first one then. Okay. Good afternoon, sir. Can I divorce my husband while my VAWA is still? I already answered that question.
Yes, but this is the continuation to that.
Oh, okay. Also, my I-485 was transferred to another jurisdiction. Is that okay? I am still waiting on my 765 after 8 months. How long does it take? Well, it's really difficult for me to predict some of this processing time. They are not consistent. USCIS is not consistent. I mean, EAD can be approved anywhere between 3 months and 1 year. And sometimes we have seen some cases, even though it has reduced lately, but we have seen cases that was more than 1 year. So that's really something that is difficult to predict. But the fact that your I-485 was transferred to another jurisdiction, that's not a problem. They do that. Right now, there is a change in the VAWA process. Before now, the VAWA office in Vermont, they only process the VAWA. Upon approval or denial of the VAWA, then they will transfer the I-485 to the local office. But they don't do that anymore. Right now, they adjudicate both the VAWA and the I-485. They only transfer it to a local office if interview is requested or required. But most of the time, 90% of the time for VAWA cases, right now, the Vermont office is the one that adjudicates both the I-360 and the I-485. Did you not skip one question in between?
No, remember that this is a continuation, so there was a question in between them.
So that question in between, has it been answered?
Yes, you did.
Okay.
This is it. The person that wants to travel.
Okay. Thank you. Afternoon, sir. If my son filing for me does not have enough income and we get a joint sponsor, will they combine the income of the two or just the income of the new sponsor? No, they don't combine income. They are going to, if you are using a joint sponsor, they are going to evaluate the income of the joint sponsor alone. They are not going to combine it with your son's income. The only time they combine income is if you are using a couple and there is an additional supplement that will have to be completed so that they look at both husband and wife, they look at both of their income. And of course, if you have been working legally for the past 3 years as at the time you apply and you have work authorization, then they can also consider your own income in addition or separately from that of your sponsor. But they don't combine your sponsor's income and the joint sponsor. So if you are going to use a joint sponsor, it has to be a joint sponsor whose income will be enough to sponsor you without adding your son's income to it. Next question, please.
This is the continuation.
Okay. Sir, I have few months left for my child to file for me. What kind of relief can I get in case there is a problem? No criminal record. This is too broad a question. I don't even understand exactly what this person is asking. What kind of relief? I don't understand. I mean, if your son is old enough to file for you, for as long as you enter the US legally, you enter with a visa, you have I-94, even if it's expired, it does not matter, and you do not have criminal record, it should scale through. The only thing you will need to prove is the relationship between you and your son. So that's all you need to do. So I don't understand what kind of relief. I don't understand that question. But I hope that my answer is enough. Next one. Good afternoon, doctor. Is it a good idea to write the senator to expedite work permit under Sinai category and file April 1, 2025? Thank you. Well, if you file employment authorization application in April, it is not even due for expedited processing, because April is just 2 months away. This is still the third month, so it's not due for expedited. I don't think it's not a good idea to use congressional liaison, but I don't think this is the kind of thing that they will be successful at. But I mean, there's no harm in trying since it doesn't cost money. So you can give it a try. But in my opinion, if you just apply in April, it is not too late. Next question. Good day, sir. How are you doing today? Good. And you? Please, can I file for an adjustment of status if my EB1A petition was approved about 20 days after entering the US on a visiting visa? Will the 90-day rule count? Well, if you already have the petition approved, yeah. The only thing is this question didn't indicate whether the EB1A had been filed prior to your entry into the US or if it was filed after your entry into the US. If it was filed after your entry into the US, then you may be prepared for the question of immigrant intent. But if it was filed prior to your entry, that's easy. All you need to do is that, well, I came here to visit. I didn't plan to stay, but my pending petition was approved. Since I was here, I just decided to apply for adjustment of status. That's easy. But the fact didn't indicate whether this petition was filed before you enter the US or after you enter the US. The next question, Dr. Olu Asekun, does this vetting of social media handle affect applicants currently in the US who are trying to change status from one non-immigrant status to another? No, at least for now. This was meant for those who are applying at the consulate. This was a release by the Department of State. The Department of State, all the US embassies all over the world, they are all under the Department of State. But people who are already physically present in the US, when they apply for immigration benefit, they are not applying from the Department of State. They are applying from the Department of Homeland Security. So far, there is no indication that it will affect those who are in the US. And remember when I was explaining it, when I was talking about privacy concern. I mentioned that it is difficult for people who are outside the US to claim any form of right under privacy law. But if you are already in the US, you can actually claim that privacy law. So I don't believe they will implement it for people who are physically present in the US. But for now, it was a policy of the Department of State, and applications filed physically in the US is not processed by the Department of State.
Okay, the person that asked earlier about if she could file an expedited request for the C9 EAD, she just sent
A follow-up.
information. Says, thanks, doctor. I'm a teacher and school year opens in August and I will lose the opportunity to get hired.
So is it a renewal?
Yeah, when she applied for the EAD, she should have included expedited request and indicate that
Maybe we
she.
need to find out if it's a renewal or a first time.
Yeah.
Yes, that's also another. That's also another thing. If we don't know if this was a renewal of the employment authorization or if this is a first time. If it's a first time, yes, you can use congressional liaison. But if it's a renewal, the receipt notice will have automatically extended the employment authorization for 540 days. So that is enough for any employer to allow you to work. And if they do, that would be a violation of federal law.
If they don't.
If they don't, if they deny you employment, that would be a violation of federal law. But if this was, huh?
She's saying it's the first time.
Okay, because it's a first time, you don't have access to that 540 days. But normally, when the application was submitted, you should have requested expedited processing and attach evidence that you have a job that you are supposed to take up by August. But since you have already filed, yes, there is no harm in trying congressional liaison. So you can do that. And you can also still submit expedited request to USCIS yourself. But you can do all of the above approach. Use congressional liaison, also submit expedited request yourself and attach evidence that you will lose the job. And of course, because I believe they also have some soft spot for teachers. Probably if you provide evidence that you are a teacher and you will lose this job if you are not able to do it, and then try the congressional liaison as well. Like I said, use the all of the above approach.
Okay, so the person that sent the 90-day rule count,
Yes.
he's sending a follow-up, says, this is a follow-up to the previous question. The EB-1A petition was filed in the US. Will the 90-day rule count for adjustment of status?
So it was filed after he got into the US, because that question says he was only here for 20 days. So it was filed within the 20 days. I'm not asking where it was filed. I know it has to be filed in the US. But my question is, was it filed after he got into the US? Because if he has only been here for 20 days, then the question is, did he file the EB-1A within that 20 days? Or has it been filed previously before he came into the US? Because those are the things that will determine whether there is immigrant intent or not.
Okay.
But generally,
I'll let you know if he sends any follow-up.
okay.
Okay.
Next question.
Okay.
Good.
Sorry. Just a feedback from the person for the EAD. She said, I will do that. Thank you so much, doctor, for everything you do, and we will always pray for your success in life. I will keep you posted.
Amen. Okay. Next question. Good morning, sir. I filed I-130 for my 4 children at the same time online. I got approved for one of them, and the other 3 still read actively processing. Is that a normal finding, sir? Well, I want you to know that immigration officers, they are human beings too. Sometimes they make mistakes. Sometimes the cases are separated. When you filed, if it is possible that all the 4 cases are assigned to the same officer. Sometimes they are separated, they are assigned to different officers. And of course, every officer, the efficiency level is different. Some officers are very, very efficient. Some officers, they take their time. So if if it was assigned to the same officer, they usually approve them at the same time. But if it was assigned to different officers, the timeline may be different. So just hope that they will approve the other ones too. But if it is already outside processing time, if it is yet to be approved, you can do a service request. But normally, if it is assigned to different officers, then the timeline may be different. Next question, please. Okay. Good day, sir. I have a pending I-751, that's removal of condition. Biometrics done 4 months ago. 10-year green card renewal. How do I get my background check before I travel out of the country? I'm not sure of my record. Voluntarily deportation 32 years ago. Is it the same person? Is it the same continuation? Oh, that's something completely different. If you have been deported 32 years ago, that will raise some other issues which are not included in this question. Let me explain how it works. I assume that whoever wrote the question is online, so you probably will answer the question, the provide additional fact that I need. When you voluntarily deported, I'm trying to understand this. Were you granted voluntary departure, or were you ever in removal proceedings? Because for somebody to voluntarily leave could mean a lot of things. Somebody can be in removal proceedings and then the court may grant voluntary departure and you may decide to go voluntarily. Secondly, you may have been here unlawfully and then on your own decide to leave. And of course, the third option is maybe you are granted post-conclusion voluntary departure. So we really don't know. But what I will tell you, before you even think about traveling, do what is called FOIA. Submit a FOIA request. Submit FOIA request to EOIR and submit a FOIA request to USCIS. Since you are using the word deportation, I'm assuming, I'm not 100% sure, but based on the information you have provided, I'm assuming that at one time or the other, you are in removal proceedings. Of course, 32 years ago, it was called deportation proceedings. It was not called removal proceedings at the time. But whatever it is called, if you do a FOIA with the immigration court, then you'll be able to have access to those records. But another problem that I foresee here is that were you assigned the same alien number? Because 32 years ago, records were not electronic at that time. So it is possible that when you came back, immigration may have assigned a new alien number for you. So one of the best ways to know if you'll be able to get a FOIA from the court system is to, if you know the alien number assigned to you at that time, 32 years ago, that will help. If for any reason you don't know it, my advice will be to conduct FBI background check. If you conduct FBI background check, if there has ever been any form of arrest by immigration, it will reflect in the FBI background check. But if there was no arrest, even if you are placed in removal proceedings at the time, it will still not reflect in the FBI background check. So it is possible that you may not get the FOIA except you know the alien number at the time. So if you are ever in removal proceedings previously at that time, so what you can do is to try to look for any document from the court that has your alien number. Then try to check whether that alien number is the same as the current one. From my experience, I can tell you it's likely going to be different because that was pre 9/11. The things were different at that time. Things were done manually by paper at the time. Things were not done electronically at the time. At that time, 32 years ago, there was no Department of Homeland Security. The Department of Homeland Security only came into being after 9/11 attack. And 9/11 attack was only in 2001. 2001 to now, that's about 24 years. It's not even up to 24 years because it's going to be September that it will be 24 years. So if you are talking about 32 years ago, that was when things were done manually with paper and everything. So I can guarantee you, I'm almost 90% certain that you probably have different alien numbers. So if you use your current A number to request a FOIA, you are probably not going to get the removal proceedings information. But if you have any document at that time that has your A number, then request for your FOIA at the time. Now, let me also give you some general information. This is not specific to your case since I really don't know what happened in your case. But the general information is that if you don't have criminal record, if you were deported 32 years ago and the deportation was not based on crime, if it was based on pure overstay or immigration violation, then if you stay out of the US for 10 years, that will erase whatever problem you have. You will have a clean slate. But if the deportation at that time has to do with crime, it's a different ball game. So I don't know the answer to that since I don't know why you were deported at the time. But if it was just because of immigration violation, once you stay out of the US for 10 years, that will wipe out whatever problem you have for as long as it is not criminal related. Next question, please. Okay, good afternoon, sir. Thank you so much for all you do, sir. You're welcome. The Lord will richly bless you. Amen. Sir, I have someone who was arrested about 30 years ago with battery and was given 1 year probation and case. Can you please move it up? And case was dismissed. Got green card 7 years ago and want to file for citizenship. Please move forward.
That's it.
So what's the question? There's no question.
Maybe if it's okay to file for citizenship.
Well, the issue is not that you cannot apply for citizenship. The issue that I see here, even though there was no question asked, but the issue that I see here is the answer to the questions in the I-485 when this person was applying for green card. There are specific questions in the application for permanent resident, and it is for such a problem as this. That is why they ask those questions. Questions like, have you ever been arrested? Have you ever been convicted? Have you ever committed an offense for which you were never arrested? So, for as long as the answer to that questions are truthful, then you can go ahead and apply for your citizenship. It's not going to be an issue because even 30 years is more than enough. Generally, for citizenship purpose, it is only criminal convictions that occurred. I mean, generally, I know there are a few exceptions, but generally, it is only criminal record that occurred after the criminal record that occurred after your green card was approved that usually affect citizenship application. But where the question, have you ever been arrested? If you didn't answer yes to that question, if that question comes up during citizenship and you now answered yes, or even if you answered no, then maybe during interview there is evidence that you have previously been arrested. Those are the areas where the problem can be. But of course, since you have not applied at all, you can still figure that out before your application. So, but whatever happened 30 years ago, especially since the conviction, since the case was dismissed, it's not going to affect citizenship. Next question. Thank you and God bless you. My I-751 case was denied in July 2023. I filed another 751 in August 2023. I received the receipt with a new case number and I've received stamp and traveled out of the country twice and returned without any problem. Last week, I received NTA to appear in court next month. The letter was mailed to my previous address on the case that was denied, which had changed my address on the new case. And I have received letters from USCIS on my new address twice. I don't know why the NTA was mailed to the old address.
I think that's it. Okay.
Okay, the new case is still pending at USCIS. My question is, what is your advice for me on my situation? What should I expect in court and going forward? First and foremost, since your initial 751 was denied, that case is closed. So the new one you filed, the address you provided in that one is not going to be automatically transferred to the one that was denied. That's not the way immigration works. That's not the way it works. So the fact that you refiled the I-751 and you provided your current address in the new application, that is not going to change anything. So you are supposed to do a change of address even with the denied one. But since you didn't do that, that was why the NTA was mailed to the new to your previous address. That is that. Now that you are in removal proceedings, what do? What you need to do is that you go to court and you file copies of the new 751 that you refiled, copies of the application and all the supporting documents, all the evidence of commingling of assets between you and your U.S. citizen spouse. The question didn't indicate whether this was a joint filing or this is a filing based on good faith marriage or based on abuse. The question didn't indicate it, so it doesn't really matter. What matters is that you go to court, you file the 751, the application copy of the one that you filed with USCIS, the second one, and all the evidence of your relationship, you file it with the court. And then you tell the court that you want the court to review the 751. So the court will review it and then take a decision whether to approve it or not. In some cases, especially if you have a lawyer, you can also tell the court that since you have refiled the 751, you want the court to allow USCIS to adjudicate the 751 that was filed with USCIS. So, because in this case, this is one of those situations where both USCIS and the court, both of them have concurrent jurisdiction over your 751. Generally, when someone is in removal proceedings, USCIS cannot adjudicate their case, but 751 is one of those exceptions. So since you have already filed it with USCIS, you can actually tell the court to allow USCIS to adjudicate it, but you still have to file copies with the court. And if the court decide to adjudicate it themselves, they also have the authority to do so. So that is my advice for you. Next question, please. Okay. US citizen married to Gambian, married in Gambia, were at the end interview is August in Dakar, Senegal. Is that a part two? Huh?
Will the travel ban?
Will the travel ban affect our process? Gambia and Senegal are on the 60-day travel ban. Can my husband still travel to come to the US? Well, I don't know if your husband already have a visa. And to the best of my knowledge, the 60 days is not yet a travel ban. It's a 60-day warning. It's a 60-day warning to those countries to put their house in order. It is after the 60 days, if they don't put it in order, that is when travel ban will now be imposed. As of today, there is no travel ban. It's only 60 days notice. So I don't know if your husband already has a visa, but if he doesn't have a visa yet, in fact, I think the fact says that interview is set for August. So do you remember when the 60 days started counting? I know it was sometimes in June.
Yeah, but I think it was last week, was it not?
Was it last week?
It was between.
No, I know it was sometimes in June, but even assuming it was June 1st, so we still have the whole of June, the whole of July. And again, even after July, it doesn't mean that as soon as the 60-day expire, they are going to be banned. So far, no. It was just a 60-day warning for those countries.
June 14.
Okay, started June 14. So if you count 60 days, that would be July, August. That would be like August 13 or August 12. Because I think July has 31 days. So yeah, that would be August 12. So again, even by August 12, it still does not mean that there's going to be a ban, a visa ban. Right now, it is a warning, a notice to those countries to try to put their house in order. Otherwise, they will be banned. So for now, there is no ban. So hopefully, your husband's interview will go through in August, and then he will be able to join you here without any problem. Next question, please. Thank you for all you do. You're welcome. Is it okay to add update documents to a pending asylum case, or will it just cause unnecessary attention? Final hearing is in 2027. Well, this is a removal proceedings. If you have a removal proceedings and you already have a final hearing set, I will hold on. It depends on how strong your case is. If your case is very strong, go ahead and add document. But if your case is not very strong, I would rather continue to gather any document that I have. I will not upload it right now, because the danger of uploading it is that the court can move forward the date. Even sometimes mere entering appearance as a lawyer, sometimes it causes the court, because of that, will move forward the date of hearing. And remember, we are still in 2025. If your case is not strong, you still have 2 years to prepare. So don't rush if it is not strong. However, if it is a very strong case, yes, you can upload it. If they move the case forward, you are ready, for as long as it's a strong case. So that would be my advice. Next question, please. Good day, sir. Oh, no. What is the update on Nigeria ban? Which date is best to travel in August? No, Nigeria has not been banned. That's what I just said. All those countries that were on that list, none of them have been banned. They were given 60 days warning to put their house in order. Part of the complaint from the US government is that many of these countries, it is difficult to identify people. People don't have a valid means of identification. A lot of people, they don't really know who is who. So that is why they are giving them that 60 days notice. And to the best of my knowledge, I know that the Nigerian government is really working on it, because I mean, while I was in Nigeria recently and I attempted to renew my daughter's Nigerian passport, and I see that there is no way around NIN. You have to provide NIN, National Identification Number. You have to provide that. You have to provide fingerprinting. You have to provide pictures. So with all that, it's going to be more difficult for people to just claim to be Nigerians without having any form of identity information. So right now, there is no travel ban. It is just a 60-day warning telling those countries to put their house in order. Hence, they will face ban. But right now, there is no ban. Next question, please. Good day, sir. Can you solicit for someone outside Texas? If so, how can I get through to have a talk with you? Well, if it is immigration case, yes, because immigration is federal. Immigration is federal law. For any lawyer to practice immigration law in the US, you are only required to have a license in at least one state in the US. And of course, I have licenses in multiple states. I can practice immigration law in any part of the United States. I can practice immigration law in California, in New York, New Jersey, Wisconsin, Colorado, any part of the United States. But if it is a state matter, yes, that requires license in that particular state. So since I'm licensed in New York and I'm also licensed in Texas, I can only handle state matters in New York and Texas. But because I live in Texas, I have limited myself to only Texas. But even in Texas, our area of practice is only limited to three: immigration, personal injury, and family law in Texas only. Next question,
Oh,
please.
and I posted the website to book an appointment. So
Yeah, if it is immigration case, because he didn't indicate whether it's immigration case.
if they want to. Oh, he already answered this.
That one?
The person posted it. Yeah.
That's the Gambia question. I've already answered that.
Yes.
No, this one, the part one.
Yeah.
Hold on.
Oh, yeah, okay, yes, you're right. Yes. This one.
Okay. Please, Dr. Olusegun, I have I-94 through a parlor. I'm married to a US citizen. Can I adjust my status? What do you mean I-94 through a parlor? I don't understand that.
I don't know what.
I don't know if they were trying to say that they were paroled, but that doesn't make sense.
Oh, maybe.
I don't know.
Maybe it is
Parole.
maybe auto adjust.
Yeah, autocorrect. Yeah.
Maybe auto correct, or what do you call it? You know, sometimes when you
Yeah.
type,
Yes.
it will automatically, because I don't know what a parlor is.
Yeah.
I think it's parole.
I think
Yes,
so.
you're right.
Okay. Let me answer it assuming it is parole. I have I-94 through a parole. I'm married to a US citizen. Can I adjust my status? This is not a yes or no answer, because there are different types of parole. With some paroles, you may be able to adjust status. With some parole, you cannot adjust status. So I don't know the nature of the parole. Number one, somebody who traveled with a pending immigrant visa application, upon re-entry into the US, they are parole. They are given parole document. Number two, somebody who entered the United States without a visa but apply for some form of relief at the port of entry could be granted humanitarian parole. Again, this humanitarian parole there are two types. There are some parole that will specifically state that you cannot adjust. But if the parole is silent on that, yes, you can adjust. Then another type of parole, for those who enter the United States without a visa, entry without a visa, IWI, and then maybe they were granted DACA, and then they travel and come back and get paroled. During Biden administration, that parole were allowed for adjustment purpose. But under this current administration, they have reversed that rule. So again, this parole, I don't know what type of parole. So you may want to go back and look at the parole. If it's a regular parole based on entry without inspection, and there is no specific annotation that says that not valid for adjustment purpose, then you can adjust status based on your marriage to the U.S. citizen. Next question, please. This one says part 2. What's part 1?
No, the red one is you already addressed that one.
Okay. Can I apply for a U.S. visa while I'm under a 5-year ban from entering Canada? Of course, Canada and the United States are two different countries. They are not the same country. However, it depends on where you are applying from. I know that Canada, US, and the UK, United Kingdom, they do share biometrics. They do share fingerprinting information. In fact, in the US, if you are in the US and you apply for Canadian visa, they will send you to the same application support center that USCIS uses for fingerprinting purpose. The same way, if you apply for American visa from Canada, they will send you to the same application support center that Canadian government uses for immigration purpose. I don't know where they send them to in other countries, but I do know that those three countries, the United States, Canada, and the United Kingdom, they do share fingerprinting information. So if there is anything that show up in your fingerprinting, usually I believe it will have to do with criminal issue. It's not going to be about your immigration record. But because I don't know what led to the 5-year ban in Canada, that's why I'm explaining this. So if your issue with Canadian government, if it does not have anything to do with crime, they may not link it. Canada and US, they are two separate countries. But if whatever happened in Canada, if it is something that involves fingerprinting, then whenever you apply for US visa, they run your fingerprinting. Because they share fingerprinting database with Canada, they will definitely know that you have this issue in Canada. But can you apply? Yes, you can apply. They are two separate countries. Next question. Sir, do you have an update concerning the issues of EAD that the administration is about to stop the issuing for asylum seekers? I'm not aware that they want to stop EAD for asylum seekers. No, I'm not aware of that too.
I think they maybe meant green card.
Well, the suspension on asylum is for the purpose of enhanced processing. I'm not aware that they stop or they want to stop EAD for asylum seekers. No, we still get employment authorization for asylum applicants all the time, including recently.
Yesterday.
So I'm not aware that they want to stop that. Next question. Afternoon, doctor. What are benefits of employment authorization, sir? Can it be tendered as ID? Oh, yes. If you have a valid employment authorization, one, you should be able to get a state ID in any state in the United States. The employment authorization card itself is a valid form of ID. But of course, some people may not be familiar with that. So if you have it, it's better to just apply for ID or apply for driver's license. But of course, the employment authorization itself, you are asking for benefit. Yeah, it allows you to work. You can use it to apply for state ID. You can use it to apply for driver's license. You can use it to travel within the United States. It is valid. It can be tendered as ID. Yes. The next question. I got my VAWA green card 2019. When should I apply for my citizenship, sir? You are long overdue for green card 2021-22. You should have applied for green card for citizenship since 2022. 2022. You are long overdue. If you got your green card through VAWA, you are only required to be a permanent resident for 3 years before you apply for citizenship. So you are long overdue. Next question, please. I changed my address online, but immigration and NVC still sending letters to old address. What should I do? Well, NVC, I don't see how you can change your address online with NVC. You have to complete a form to do that. I don't see how. So if you don't do it properly, definitely NVC is going to continue sending.
Maybe through the MVC online inquiry. I think that could be.
Well, if you send it through the NVC online inquiry, if they acknowledge it, then they will update it. Because what you need to do is, if you fill that form through NVC online inquiry, provide an email where you can be reached, and make sure it's a working email, because sometimes when NVC sends an email and it bounces back, then they are going to send you physical mail. So just make sure you use email that is valid, and cross-check the email multiple times before you submit the form. Once they acknowledge it, because normally once you do that online inquiry with NVC, they usually will acknowledge it. They will respond. I don't know the timeline, but they would certainly respond. Once they respond and they tell you that, yes, your address has been updated, from that moment, they will not send physical mail. But until that is done, they can continue to send physical mail. And it's so easy to miss physical mail, especially if you have changed your address. So just go online and do the NVC online inquiry. NVC online inquiry. Make sure you provide an email address in that inquiry and wait for their response. I know for sure they will respond. What I don't know is how soon, but they will certainly respond. Once they respond and they acknowledge it, from that moment, they will not send anything paper. Next question, please. Good day, sir. Doctor, thank you for your service. You're welcome. Please, any arrest and citation before one gets legal status affect one's travel internationally? The person has done several background checks but no record. No, it doesn't affect it. Once the arrest was prior to the green card, it will not affect it.
This is the next one, but it's too long.
Hello, sir. God bless you for what you are doing. Amen. I filed an I-130 visa for my family that is in Nigeria in 2022 and was approved by the USCIS and NVC in 2024. and we have been waiting for the embassy in Lagos to invite my wife for an interview. I've been under the care of the Veterans Administration since 2021 when I was diagnosed with blood cancer. The VA, also on our behalf, submitted a health letter to the NVC to expedite my case based on my situation, but the NVC replied me as the petitioner that only the embassy in Lagos can expedite my case and that they have rejected the request from the VA. I've also written the NVC every 3 months to reconsider my case, but the answer has always been the same, that the embassy in Lagos still will not expedite this case. What is the next step to take, sir? Thank you for the question, and sorry for the cancer issue. Uh, I believe very strongly that this is a case that actually warrants expedited process. And I can guarantee you that the expedited process will be granted if you do it through the normal process. What I will advise you, you do two things. Number one, use congressional intervention and let them send the request to the embassy. The embassy is actually right. The request has to be submitted to the embassy, especially if your case has been documentarily completed. There is nothing the embassy can do about it. So they are actually right. So the request has to be sent to the embassy. So what I will advise you, use congressional intervention, give them a copy of the response from the NVC telling them to submit the request to the embassy. Every congressman in the United States have liaison office, and they have a direct communication with the US embassies all over the world. So it will be more accurate, and it will be more, they will attend to it more speedily. I mean, we have taken steps, even in a case that is not as serious as this, using congressional intervention, and then they sent it to the embassy, and the embassy responded within a few days. So the embassy is correct. So send the expedited request, send it to the embassy directly in Lagos, but use congressional intervention for more effective outcome. The next question. Good morning, sir. Please, I'm a green card holder. Can I travel on a 2-week vacation with my family?
And then she sent this one here.
Is it illegal for a green card holder to travel to Mexico just for vacation? No. There's nothing illegal. You can travel with your family. There's nothing illegal. The only time we warn people against traveling is when criminal record is involved. If you don't have criminal record, there's nothing illegal about it. You can travel to Mexico. The only thing I don't know, because I don't want to misadvise you, I don't know. Maybe one of my team members here can help. A U.S. green card holder, do they require a visa to enter Mexico? That I don't know. As permanent resident of the United States to Mexico, do they require? That I don't know. So if you need to find out so that you don't get into trouble, don't just assume because you are a permanent resident and then you just go into Mexico and then you face challenges over there.
Possible for Canada, but I'm not sure about Mexico.
Yeah. So I'm not sure of that, but somebody is checking for us. But other than that, for as long as you don't have criminal record, you can go to Mexico. But if visa is required, make sure you apply for visa before you go. Because if you don't apply for visa, if you go into Mexico and then you run into problem, America will not be able to protect you because you are not American citizen. You have to rely on your home country, Nigeria, before you can come back to the US. So that's a risk you don't want to take. And that is why it is important to verify whether you need a visa before going to Mexico or not. I don't think American citizens require a visa to go to Mexico, but I don't know about.
I mean, they still need to register.
That's permanent resident?
U.S. citizens.
Yeah.
Oh, U.S.
They still
citizen?
need to register like this immigration form, and then they present themselves at the port of entry, and then they're allowed in. But for permanent
So
residents,
where do you submit that form when you are
it's online.
going?
It's called FMM.
Okay, we'll talk about that because
Yeah.
I'm planning to go to
Yes.
Mexico next month and I've
Yeah.
not done any registration.
Oh, okay.
I didn't know that U.S. citizens need to register to
Yes.
go to Mexico.
Yes.
Oh, okay. Good to know. Thank you. So again, I've just been told now that even U.S. citizens need to register to go to Mexico. So permanent resident, if there's, is that the answer?
Yes, for the permanent residents.
Okay, thank you. Okay, this is the answer. For U.S. green card holder, Mexican authorities allow entry for tourism, business, or transit without a visa if you present 1. Your valid Nigerian passport, 2. Your valid U.S. permanent resident card. You also need to complete a former migratoria.
Yeah, like the migration form or
Yeah.
immigration
Okay,
form.
yeah, like complete immigration form or tourist card. You need to pay and obtain online on arrival for up to 180 days. This is for Nigerian passport holder who are permanent resident in the US. So that answers your question. Can you go to Mexico? Yes, but make sure you follow the procedure that I just read now. Next question.
Yeah, and the form is called FMM.
Okay, the form for permanent US permanent resident, Nigerian passport holder, permanent resident.
Also U.S. citizens, yeah.
Oh, the US citizen needs the same form.
Yeah.
Oh, okay.
FMM.
Yeah.
FMM.
Form MM. FMM.
And it's fillable online.
And it's an online form. Okay. But that thing says should be submitted on arrival.
It can be done online, so they pre-register, and then they just get to the port of entry and present the form because it will give them like.
So when you register, you still have to print it out
Yes.
and then submit
And
it when
present the passport and the green card.
and the green card at the port of entry.
If the length of stay is for more than a week, then they will be asked to pay a certain fee. But if it's less than a week or a week and less, then it's free.
Okay. Well, I've been told that if the length of stay you plan to spend in Mexico is less than a week, you may not pay some money. But if it is more than a week, you will need to pay additional fee. Next question, please.
I think this is it.
Oh, that's the last one.
No, this is the next one.
Oh,
yes,
okay.
And that's the last question, yes.
This one doesn't seem to start. It says traveling with VAWA. Is that
I
the
think
beginning?
Maybe that's just the follow-up, the one that said parlor. Let me see if that's the same
No,
question.
that's a different one. I know.
No, it's the only question, so I don't see any
Yeah.
the same name.
Okay, let me just read it like that. Okay. Traveling with VAWA advanced parole. I have trip to make in August. I have no criminal record. In case Nigeria is eventually included in the travel ban, will that be an issue for my planned trip? No, because you are not applying for visa. Travel ban only affects visa holders. When you travel with advanced parole, you are already, it shows that you are already living here. You are only on a foreign travel. You don't need to go to the embassy, so it doesn't affect you. Okay, that will be for now. I also realized that it's already 15 minutes after. So that will be for now. We hope to continue again next week. Please stay safe. Hopefully, the administration will relax all the things that are going on right now. And I do know that the Congress is working on something, but I don't know what it is yet until we see it. I heard in the news, this is not official source, it's in the news on CNN that Congress is trying to come up with something before the end before July 4. Well, I don't know how far it is true. Like I said, this is not from official source. It is from the news. So I usually don't rely on unofficial source, but I just wanted to mention it. So until we see you again next week, please stay safe. God bless you.